Major breaking news out of the state of Colorado, which could have major implications for our Second Amendment rights before the United States Supreme Court. Turns out the state of Colorado intends to ban all semi-automatic rifles that are capable of accepting detachable magazines. Well, that's what they think they're going to do, but this proposal may have come at a perfect time to remind the United States Supreme Court of what's at stake if they refuse to grant cert in the Snope versus Brown case. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist for a 2025 Gun News Award in the category of Top Voices of the 2A, Top Voice of the Second Amendment. Always an honor to be a finalist for the Gun News Awards. I've been a finalist several times, but this time we're going to break through and hopefully win one. We'll see what happens at the end of January. All right, folks, so Napoleon Bonaparte, the former emperor of France, once said, you never want to interrupt your enemy when they're making a mistake. Now, with that in mind, one now wonders whether or not the anti-gunners and their handmaidens in the legislature of the state of Colorado have just given a gift to the Second Amendment movement. How so? Well, it turns out that on the first day of the legislative session, or at least the beginning of it, a whole bunch of Democrats, both in the Colorado Senate and, of course, in the Colorado House, have decided to come out and propose in something that could very easily pass based on the demographics of the, or at least based on the political affiliations of the House and the Senate in Colorado. They may very well try to and actually pass a law that bans the sale, manufacture of semi-automatic firearms that do nothing more than accept detachable magazines. These would be banned under the Colorado bill that's being discussed, and I'll put a link to some of the articles, including by the newspaper Colorado Sun, in the description of this video. Now, the reason why this is significant is this is occurring literally on the eve of the United States Supreme Court conferencing 4 Second Amendment cases, one of which is Snope versus Brown, which deals with the Maryland AR-15 ban or the semi-automatic rifle ban case. And we've talked a lot about Snope versus Brown, as well as the other cases that are up for consideration of a possible grant of cert. And just as a reminder, we want the Supreme Court to grant cert in one or more of these Second Amendment cases, because if they grant cert, what that means is they will take these cases and decide them on the merits. Thousands and thousands of cases come before the U.S. Supreme Court every year with requests or petitions to take the case on cert, meaning they want the case to be heard by the Supreme Court, but the court only takes about 60 to 70 cases a year, and we want at least one Second Amendment case to be taken this year, right square on the merits of what the Second Amendment means and how it applies to modern-day gun control laws. Now, it turns out that just literally on the eve of the Supreme Court conferencing these 4 Second Amendment cases, including Snope versus Brown dealing with the AR ban case in Maryland, the Ocean State tactical case dealing with the ban of magazines that hold more than 10 rounds or whatever it is in the state of Rhode Island, as well as a couple other cases, this Colorado proposal on the eve of the Supreme Court conferencing of Snope versus Brown could be a gift for the Second Amendment movement, because it's going to remind the Supreme Court just how important their decision to not take the case or to deny cert in Snope could be in the real world, because the anti-gun movement is pushing for these AR-15 bans. They want to ban them across the country as best as I can tell, and they want to do it state by state until they get control of the federal government. And they want the Supreme Court to stand down and not to enforce the Second Amendment. So specifically, here's what Everytown, obviously no friend of the Second Amendment in my opinion, here's what Everytown had to say about why this legislation in Colorado is so important that it get enacted. While Colorado already has a ban on high-capacity magazines, high-capacity magazines are legally sold in every single state neighboring Colorado, and the high-powered military-style firearms that are compatible with high-capacity magazines are currently legal to purchase in Colorado. This makes the current ban on magazines, presumably, incredibly weak, because someone can easily just go buy a magazine in a neighboring state. Legislation to amend the state's high-capacity magazine policy to also ban the purchase and sale of military-style firearms that would accept detachable high-capacity magazines would close this loophole and save lives. So it's very interesting what Everytown just said. Everytown said that the right to buy semi-automatic rifles is a loophole to a ban on magazines that hold more than 10 rounds or whatever it is, to bans on so-called high-capacity magazines, which are really just standard capacity magazines that, come with all semi-automatic pistols and rifles and so on. Nevertheless, they want to go to the extreme measure of banning these semi-automatic firearms that are capable of taking or attaching detachable magazines, or accepting these detachable magazines, which to me is quite crazy. Now, the good news is people have taken notice of this, and I suspect the Supreme Court is going to take notice of this when they conference this case, and they probably have already done so. In fact, it's such a high-profile thing that a friend of this channel, Stephen Halbrook, actually published an article late in the day on Thursday pointing out this connection between what Colorado was doing and the importance of the Supreme Court granting cert in the Snope case dealing with the AR-15 ban out of Maryland. Here's what Professor Halbrook had to say. 4 Second Amendment petitions were distributed for the court's conference on Friday, January 10th. I just posted on the merits of these cases. A dramatic development has just occurred showing the dire need for the court to clarify its jurisprudence in this area. The best case to do so is Snope versus Brown, which concerns whether Maryland may ban semi-automatic rifles that are in common use for lawful purposes. Here's the urgency. Yet another state, Colorado, is about to ban virtually all semi-automatic rifles, large numbers of semi-automatic pistols, and even a large number of semi-automatic shotguns. The previous state bans encompass America's most widely held rifles, such as the AR-15, but they do not apply to semi-automatic rifles that do not have pistol grips or other cosmetic features. The Colorado bill will ban all semi-automatic rifles that use a detachable magazine, which means almost all semi-automatic rifles. No other state goes that far. So that's some powerful observations by Stephen Halbrook. So the question then becomes has the anti-gun movement in Colorado caused the U.S. Supreme Court to take a look at this Snope case, and will it be enough, if it was even needed, to push them over the line, to push them to agree to grant cert in the Snope versus Brown case, because this is an issue that's not going away. And every one of these arms ban laws dealing with AR-15s or semi-automatic rifles, you are disenfranchising, you are taking away fundamental Second Amendment rights from tens of millions, if not, tens of millions of Americans who live in these jurisdictions like California, Maryland, New Jersey, New York, Illinois, and now maybe Colorado, right? You're taking away their Second Amendment fundamental rights with allowing these laws to stand. Now, what will the Supreme Court do? I don't know. I'm certainly cautiously optimistic they're going to take one of these Second Amendment cases this term and decided they certainly should take at least one, maybe more than one, but they should take at least one. And the question is going to be, will this Colorado attempt to ban these rifles on the eve of the Supreme Court's conference in Snope, in Ocean State Tactical, in Gray versus Jennings, in Maryland shall issue? Will this somehow push the Supreme Court to take a case that they might not otherwise have taken? Very interesting question. We will certainly know a lot more about what the Supreme Court is thinking in terms of Second Amendment jurisprudence in the next few weeks, and I hope it's good news. I'm cautiously optimistic, but I don't control the Supreme Court, and whatever they decide to do, they're going to decide to do. But I got my fingers crossed, I've got my candles lit, and my toes crossed, and so on and so on. So there you have it. All right, folks. Well, hope you learned something here today about the potential connection between the Colorado semi-automatic rifle ban and the U.S. Supreme Court's deciding, in their conference on Snope versus Brown. We'll see what happens. Make sure you follow me on X at @4boxes Diner. We have 22,000 followers. Make sure you subscribe to this channel both on YouTube and Rumble. We're now posting on Rumble now because a lot of people like that platform. And again, feel free to share this video, subscribe, like this video, and so on, because we are trying to grow our ranks of supporters here at the 4 Boxes Diner. And again, we appreciate your support, and I look forward to speaking to all of you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.